How to monetize intellectual property. Video 5. Proven ways to create and protect intellectual property. Steps 6 through 8. Hello, Joel Douglas here. I am an instructor, guest lecturer with the Shelby Colum Davis Professor of American Business and Economic Enterprise at Trinity College. Thank you for watching this series. This part of the series continues the focus on beginning to attract investors, form the company, and expand your intellectual property. Let's take a deeper dive into proven ways to create IP and protect its value. Step 6. Approximately 9 months after the filing of the provisional patent applications that best describe your fully featured product and ensures that you have priority over any prior art, engage a patent agent to draft and file your regular non-provisional patent application. A list of patent agents can be found on the USPTO website under Patent Practitioners. Using a patent agent versus a patent attorney for this service will save you approximately $150 per hour. Regardless of how you file the non-provisional patent application, ensure that the patent application is filed before the 12-month window closes and that you claim priority to all applicable previously filed provisional patent applications. Not doing this on time puts your whole company at risk. Please note, at the conclusion of the 12-month window from filing the provisional patent application, you will have formed a corporate entity and thereby required by law to file using a licensed patent practitioner and assign the patent to the corporate entity. During this period, while you are filing the non-provisional patent application, you should determine whether your product would benefit from filing a design patent application. A design patent covers the ornamental design aspects of your product, whereas a utility patent covers functional aspects of your invention. The licensed patent practitioner will be able to help you determine the merits, potential, value, and the appropriateness of filing a design application. We mentioned previously forming corporate entities. I've saved this discussion to step 7, but this activity occurs sometime, preferably earlier in the 12-month period. Forming a corporate entity to house your invention so you can raise money without placing your assets at risk. My recommendation for startups is to form an S corporation or S corp. An S corp pays no income tax and may only be used for small businesses. All the income or losses of the corporation for the year are passed through to the shareholders, who report them on their individual returns. At the end of each year, the corporation files an information return listing all its income, expenses, depreciation, etc., and sends each shareholder a notice of his or her share as determined by a percentage of the stock ownership. Using this method avoids double taxation and allows the pass-through of losses or profits to the shareholders. Since tax losses are common during the initial years due to the startup costs, many businesses elect S status and switch over to C corporation status in later years. Be aware that once a corporation terminates its S status, there is a waiting period before it can switch back. Typically, S corporations do not have to pay state corporate income tax. There may be other benefits such as investor tax credits available in your particular state. There are a number of internet-based companies who can help you set up your company for under $300 plus any state filing fees. You must file an S corporation form and apply for an employer identification number, EIN, with the Internal Revenue Service. The EIN will be used to report earnings and losses for the company. to the IRS. A number of other federal and state forms are required, so finding a good, low-cost advisor in this area is essential to help you comply with the law. A number of companies can assist you with the filings and keep you out of trouble with the Secretary of State, state tax boards, and IRS. Once a company is formed, any and all trademarks, copyrights, provisional and non-provisional patents, all IP need to be assigned to the corporation. Equally important during this stage of forming the company is the establishing a experienced, credible board of directors. These are seasoned professionals who can provide honest and qualified advice. In addition to the board of directors, you must recruit industry professionals, subject matter experts, and thought leaders for your scientific and product advisory board. People serving on these boards help guide you through the nice-to-have versus the essential features for the product. They will also help you secure beta test sites and initial customers, all very important. We are at step 8 in the process, growing the company. It's really hard work for the inventor and one that often leads to failure. Adding employees, management, engineering, marketing, sales, operations, and administrative staff need to be successful to grow the company. And convert the product from an idea to reality is a difficult and challenging journey. Many times it requires giving up ownership and control of the company to a new leadership team, a tough thing for most entrepreneurs who view their invention as their baby, not a vehicle for wealth creation. They often can't let go of the scientific and engineering details or understand the sales and marketing strategies. It takes a diverse set of skills and team members to drive invention success and help the entrepreneur fulfill their dream of commercialization. Many times, more seasoned C-level executives are needed in exchange for significant company ownership. But without the right people driving the company, particularly securing investment capital and forging business partnerships, commercialization and business success are simply not possible. Thank you for watching, and I look forward to seeing you again for the 6th video entitled Proven Ways to Create and Protect Intellectual Property, the Final Steps.